So, some female police officers in British Columbia were trying to bring a class action lawsuit against their municipal police forces. They were alleging some pretty serious stuff, like systemic sexual harassment and discrimination based on gender and sexual orientation, not just from fellow officers, but from management too. The core of their claim was that these police agencies weren't doing enough to stop, investigate, or fix this toxic behavior. They argued that a lawsuit was the only real way to address the collective and system nature of these issues, seeing it as more than just a workplace dispute. They felt that due to their vulnerability as female officers, a class action was necessary to hold these municipalities and police boards accountable for what they described as a poisoned police culture. However, the BC Court of Appeal has now ruled against them. The court basically said that while their arguments were compelling, labor laws give unions' grievance processes exclusive jurisdiction over these kinds of disputes. The judges felt the lower court judge was correct in determining that these complaints fall under that union contract process, and therefore, the courts aren't the place to settle them. The appeal judges essentially agreed with the original ruling, stating the officers didn't present a strong enough case to overturn it. They found no significant errors in the lower court's analysis, which concluded that the proper avenue for these complaints is through the established grievance procedures within their union contracts. This means the path forward for these officers to address their allegations of discrimination and harassment will be through their union's internal processes rather than a public court battle. The court's decision emphasizes the legal framework that prioritizes collective bargaining agreements for resolving workplace disputes. That's your Toronto News Today update. AI powered and always on.